6 o'clock, so we'll go ahead and get started. Feel free to filter on in, find a seat. My name is Blake Bingham. I'm the Assistant State Engineer who is responsible for water rights adjudications. We'll cover what a water rights adjudication is. It's obviously the thrust of this meeting. But before we get started, kind of some rules of engagement here as far as what the expectations are and what they are not. First of all, I understand that you received a summons in the mail, and that can be intimidating, and maybe some of you feel that that's obligated your attendance at this meeting tonight. I just want to be clear up front that you're not obligated to be here. That summons is a legal requirement that we are obligated to put in that notice. I apologize if it startles, but it is intended to get people's attention because this is a legal proceeding, but we'll cover that more in depth as we go throughout the night. But if you feel any time that your curiosity has been satisfied, feel free to stand up and make your way out and go ahead and exit out the doors you entered in earlier this evening. And the contact information, if suddenly you get home and you realize you did have more information or more questions, this broadcast or this presentation is being streamed live, but it's also being recorded. You'll be able to view it at your leisure later on. So before we get started, just to introduce a couple key individuals. First of all is Kent Jones. He's the director of the Division of Water Rights, also known as the state engineer. So he's the state engineer when we talk about state engineer. Next to him is Ben Jensen. He's the attorney general representative. He's the counsel for the state engineer. And then Gary Brimley, who is kind of my deputy. And then Tamara Prue, you probably met her. She was out in the hall. I don't see her. She's probably still answering questions. She's going to be the team leader for this particular area. So she's going to kind of be directing the boots on the ground efforts. She'll be calling you if you submit claims. So she'll be answering a lot of your questions. Then I have some other staff here that are here to help answer questions following the meeting or even during the meeting. And if you feel like you have a question that you really want answered that's specific to your particular scenario, feel free to step up and walk outside in the hallway, and they can answer your individual question. But if there's a question that you have, and this goes for those of you who are viewing online, if there's a question you have that's for the general group that maybe applies to everyone, feel free to ask it at any time. I'm happy to answer those. Sometimes that helps prompt other discussion points that people are wondering. And quite honestly, usually what happens is someone finally works up enough courage to ask a question, and then the floodgates open up and we have some good discussions. But if we get too far afield, I might kind of say, all right, we need to wrap it up and move on to the next slide, just so that we can get through this presentation and those people who want to see the conclusion of the presentation can make their way home. Here's our agenda for this evening. We're going to talk about the general adjudication process. Sometimes I'll call it a water rights adjudication, or I'll just call it the adjudication. The proposed determination process, which is a part of that general adjudication, and then some of the significant issues, the anticipated timeline that we have. And then again, we'll have questions at the end. For those of you viewing online currently, if you have questions, go ahead and utilize that email address you see at the bottom of the slide, and shoot me an email, and then at the conclusion of the presentation, I'll pull up my email and I'll look at the questions, and then I'll answer them for the good of the group as well as those viewing at home. If you don't get your question in by the end of the presentation, you still feel free to use that email address to fire me off a question, and we'll get an answer for you tomorrow or the next day. So without further ado, let's go ahead and kick it off. Generally, the community at large is not very well versed in the concept of water rights. And so before we kind of dig into the concept of a general adjudication, I'd like to cover briefly what a water right is first. And so a water right, it's different than a connection to a municipal water provider or something to that effect. It's really a right to divert water from a natural source, whether that be a spring or a stream or even the groundwater, and beneficially use that water. And those water rights, they consist of different elements. You have a defined nature of beneficial use. So that's really what you're using that water for, whether it be for irrigation or for your domestic residents or for stock watering. Those are common types of beneficial uses. A priority date in essence, kind of puts you in line as to when you get your water compared to other people. Though Utah is a prior appropriation state, what that means is kind of like a mining claim is first in time and first in right. And so water rights will come with these priority dates to determine if you're on a stream, if you got your water before someone else. A defined quantity of water, and we quantify water or the flow rate of water by either using a cubic foot per second, which we abbreviate by CFS, or by an annual volume, which we measure in acre feet. So if you imagine a lot that's an acre in size and an amount of water that's 1 foot deep, that is an acre foot, and we use that over an annual use. So that's kind of a volume quantification as opposed to a flow rate quantification. They have a specified point of diversion, which is the place where you're taking that water out from the natural source. So for underground systems, that would be the well. For a stream, that would be a diversion gate, a head gate. For a spring, sometimes that's a spring box. And so that's what we call a point of diversion. So you'll hear that term often tonight. And then a specified place of beneficial use, which is pretty intuitive. It's where you're using that water, and we measure that using the public land survey system. I won't get too far in the weeds, but it is kind of a system that is pervasive in through the government land office and established, and so it's something that we use within the water rights community. So what gives you, a question we get a lot is, I don't know if I have a water right. And so we often answer that by saying, well, generally people who have a water right are pretty familiar with the structures that are associated with them because they will often require maintenance or repair or those types of things. And so some things that might be evidence of a water right would be a well located on your property, any irrigation ditches or head gates or a spring box, those types of structures that may have been built by the previous owner of your property, and then, when they sold it to you, they conveyed those to you, but maybe you didn't know that the water right came along with the property, which in most cases it does. What a water right is not. It's not the same things as share in an irrigation company. Sometimes we'll hear the concept of water share and water right conflated or used to mean the same thing. But really what a share represents is like a share of ownership in a company. And so when you have a share in an irrigation company, in essence, the irrigation company owns the actual water rights, and then they have shares that they then distribute to their shareholders, right? And so a water share and a water right are not the same thing. Now, just because you have shares, does that mean you shouldn't be interested in this process? No, because we want to make sure that you go and if you are a part of an irrigation company, that you make sure that they are participating in it. But it's going to be the owners of the water rights who are going to be required to participate in this process. Also, it's not a connection to a public water supplier like Salt Lake City or whatever, wherever you get your water bill, okay? Again, they own water rights, and they use those water rights to get the water, and then they obviously clean it and distribute it to your taps. But just because you have a culinary connection does not entail a water right associated with that. And to kind of put everyone at ease, these public water suppliers are very aware of this process and have been actively engaged in it from day one. Yes, sir.
So let's say, for the sake of argument, that I've got a special warranty deed on my property, and that if you trace back the records in the county recorder's office, there's been no easement to the water conveyed to anybody. Would I be able to create something like this and dig a well for standing water or something like that? Is that a right that I have?
That's a good question. Let me summarize it for the sake of the rest of the audience. So he said, I have a warranty deed on my property, and if you try to trace it back through the county recorder's office, there's no discussion of any water rights or any conveyances or anything like that. Would I be able to utilize that then to create a water right? And the answer is no. To appropriate a water right, you appropriate it through the division of water rights. Simply having a warranty deed, and often a lot of these deeds that you see with your property will have boilerplate language that says all water rights, conveyances, et cetera, et cetera. Now, even if you on the flip side of that is if you have a piece of property conveyed to you and it's silent with respect to any water rights, Utah law states that it's assumed that the water right transferred by appurtenance unless it was explicitly withheld. So that's the flip side of that, that even if it's silent, you may still have a water right, assuming that there was a water right in the first place. But simply because a deed mentions a water right or the conveyance of water right does not necessarily give you a water right, nor does it give you the opportunity to create one out of whole cloth. Does that answer your question? Yes, sir.
What if we've lost our paper deed? Can we get another copy?
So his question is, what if we've lost our paper deed? Can we get another copy? I presume those deeds have been recorded at the county recorder, and so that's where you would need to go and find that. All right. Let's keep on. Yes, sir.
So on this handout, there are red dots. What are the red dots? And that's different from what I found in the PDF online.
Okay. So you may have noticed on that handout, on the map on the back, it has a bunch of red dots. And I was going to get to that here a little bit, but let's just answer that now. Those actually represent points of diversion within this area. So if you see something by your house, and we'll have a bigger map after this meeting where you can go and look at it. And I'll also show you the online interface where you can zoom in straight to your house and see if there's anything nearby. So those represent the points of diversion. And interesting you should ask that, because in this particular subdivision, there is actually quite a lot more water rights than we typically see. I think there's somewhere upwards of 600 plus. Is that right, Tamara? Yeah, which is pretty dense for this area. So you can see that those clusters, and you can see that there may have been a well. Now, does that mean that well is still there? No, all that means is at one point we had on our records a well located there. That doesn't mean that it could have very easily been paved over and turned into a Walmart parking lot and may not exist anymore, but at some point we had those on our records. And we'll talk a little bit more about how accurate those dots really are, but they should give you a sense of, in this area, that there may be a water right there. Let's keep on plugging around. So when we talk about water rights adjudication and trying to figure out why we do this, I like to provide a little bit of historical context, and it's just a brief overview of how we got to where we are. Because if you drop the general adjudication in today's day and age, it's going to look like it's way out of place. Like, why are we doing this? But so a little historical context will kind of get us to that point of why it's necessary and why it's helpful and beneficial to the state of Utah and to the public as a whole. So we know the story when Brigham Young entered the valley in 1847, July of 1847. Actually, the Advanced Party of Pioneers entered in the day before, July 23rd. And they started diverting the waters of City Creek to soften up the land there to raise a late crop of, I believe, potatoes. And then they built their mall on top of it, of course. Later that year, or maybe the next year, Brigham Young kind of made a statement that's kind of been the basis for how water rights have operated in the state of Utah ever since. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people." And so really that's the basis for water rights, is that the water is owned by the public. The Division of Water Rights, we simply administer the right to divert and to make that orderly and in a organized fashion. But in essence, the waters really belong to us as citizens of Utah. Well, between 1847 and 1850, what we now know as Utah was actually a part of Mexico, and then Brigham Young was really trying to get it to be, adopted into the Union, so he came up with this quasi-ecclesiastical state of Deseret, and then finally became the territory of Utah. And so we see this transition and finally becoming a part of the United States, but water was being diverted, right, to satisfy the needs of the settlers. And they were kind of done on a community basis just to satisfy the needs of those early settlers up and down the Wasatch Front, up into Idaho, down into St. George, and down into Las Vegas. As settlers kind of established these communities and diverted these, the doctrine of priority evolved. So you had the first settlers who would establish these settlements, and they would do all the work, dig the ditches, divert the water, put all the labor into diverting the water out of these canyon streams. And so when subsequent settlers came, they said, well, we want you to have access to this, but since we put all the work in first, we get the primary right on it, and you get a secondary right. So this concept of priority began to evolve, and this was later mingled in with kind of the mining claim priority of first in time, first in right. And so in Utah, this is why we have priority dates, and really throughout the western United States, this has been adopted, the system of prior appropriation, where first in time, first in right. Because water is a limited resource, and so really the only fair way to distribute that is to appropriate it to people who claimed it first and used it first. As a result of there not being really any acting government, conflicts were settled by the LDS Church. You had bishops' courts that kind of acted as the local magistrate, right? And then you had the stake president and the high council who acted like an appeals court, a court of appeals. So if you didn't like what the bishop told you with regard to how you could divert your water, you'd say, oh, forget you, bishop. And you go to the high council and they'd make a ruling. And this was just kind of because they had nothing else. The church filled that power vacuum. Well, in 1852, the first territorial legislature attempted to kind of migrate away from that church-centric power structure. And so they decided to make the county court responsible for all the timber and water and privileges and really, but the problem is the county judge or the county court, well, those were elected officials, right? And so can you imagine that the people who they chose to elect into those positions were the same people who were their bishops and their stake presidents, right? So there wasn't a whole lot of difference. And in any case, Salt Lake County is really the only county that abode by this. So the rest of the Utah pretty much did what they wanted, or the territory of Utah. Continued to divert water and act on this first in time, first in right, and the church continued to act as kind of a governing authority. Well, in 1877, the United States Congress passed the Desert Land Act. And really the main thrust of this is they were trying to get people to move out west, to settle the west. But they couldn't do it under the same construct as they were used to in the east, where in the east, if you had water running adjacent to your property, you had a riparian right. You could take it and use it on your property just by virtue of the fact that you were adjacent to it. Well, they realized that wouldn't work in the west, that you would need to divert water and move it several miles away even and irrigate. And so when they created this act, they in essence, first of all, they delegated authority to their respective state or territory for administering water rights, which to us seems sensible, because we're here and we have that now. But back in those days, remember, it was the government land office that was issuing patents for land, so you could have just as well thought, well, maybe they'll just do the same thing for water rights. You have to go through the federal government to get a water right. Well, this act essentially cast it to the territories or states, and also severed that relationship of the water from the land. So now you could divert water and move it many miles and irrigate somewhere else so that you could then patent and homestead that. In 1880, the territorial legislature attempted to remedy the fact that no one was really abiding by their 1852 statute. So they said, well, we're going to appoint these county selectmen, and they're going to adjudicate the waters, and they're going to make sure that people are diverting and have certificates. It was largely ignored, and I think it was even found not unconstitutional because these were appointed officials to the executive branch dealing with water rights, which are typically the purview of the judicial branch. As a result of this, confusion continued to be pervasive in spite of the best efforts of the territorial legislature or the LDS Church, and the church continued to administer and decree water rights. And I cite this example often. In 1879, there was a High Council decision that diverted and distributed the waters of Spanish Fork River, and that is still how that river is just largely distributed. There were subsequent decrees, but that High Council decision kind of established what irrigation companies got what, and that's largely in place to this day. So now we move into statehood. Well, for you history buffs, obviously 1896 is when Utah became a state, and there was a lot of controversy over the new state legislature and any prospects that the state was going to come in and take everyone's water rights. They're going to say, oh, you don't have a water right. We're going to take them all, and now it's all owned by the state. And so there's a lot of controversy over that. So they decided, well, we aren't going to address water rights initially, but we will do one thing. So in Article 17 of Utah's Constitution, they wrote one clause that pretty much said, hey, if you have a water right and you're using it, you're good to go. You can continue to do so. It said, all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. So if you had one, you could continue to use one. And they, in essence, said, we'll continue to figure this out later, and we'll deal with it. We'll kick the ball down the road a little bit. Well, in 1897, the Office of the State Engineer, what we now know as the Division of Water Rights, was created. And his mission was really to more or less do a map of Utah to see where these sources existed, where they came out of the canyons, how much water there was. And so although he was kind of on the periphery of this water rights concept, that still he didn't really have much to do with the theory or the appropriations of water rights. They were largely still done by going and staking your claim, pounding in a stake by where you diverted the water, and then go filing that claim at the county recorder or the post office. Well, in 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, was established, and they were given the mission to reclaim the arid West. And how they do that? They would go and build gigantic dams and make big irrigation projects, right? In the hope of selling that water at a discounted rate to farmers who would then cultivate ground and use it to irrigate their property. Well, the Bureau of Reclamation or the Reclamation Service was very reluctant. Actually, they were adamant that they would not build any of these projects in any state until that state had adopted some type of comprehensive water law, which included identifying historic rights. Remember, people had been using water all the way from 1847 to this point, and in essence had water rights by virtue of the fact that they had been grandfathered in. Well, the Bureau didn't like building these huge projects without knowing that they had water to fill those dams, right? And so it's no coincidence that in 1903, Utah came around and decided to do a comprehensive water law, which included the appropriating of new rights, but the recording of all existing rights. And really what they pretty much said is, hey, we want to adjudicate all these old rights so we can find out what they are, where they are, how much they are, but we're pretty much just going to tell the court to do it. Well, that's great, but the legislature didn't really provide funding to the courts to do it, and the courts didn't really know how to do it, because in a court system, you have to have an adversary, you have to have a defendant and a plaintiff, right? Well, in a general adjudication, there's not really a defendant and a plaintiff. If you just tell a judge to go figure out how the water rights should be, well, unless he has a case come before him against two people that are arguing, he can't really make a decision based on the merits of legal precedent. And so really nothing happened with respect to adjudicating these old rights. Well, in 1919, the legislature finally caught on and decided to create the machinery that would allow these water rights to be adjudicated. And what that is called the proposed determination. That's largely how we operate today, where the state engineer has the responsibility for making an evaluation of these rights and then making that recommendation to the court. And the state engineer is now a plaintiff or a party in this civil case, and everyone else is a party to this civil case. That's why it's a general adjudication. It's comprehensive, it includes everyone. And so that way it gets it before the court, the state engineer provides his recommendation, and then it's litigated. And we'll get into kind of the finer details of that here in a bit. So 1903 was just for surface waters, right? You needed a water right now from 1903 onward to divert water from surface water, so streams and even some undeveloped springs. Well, up until 1935, you could still drill a well without a water right. They didn't recognize that it's the same water. Well, finally they caught on, right? That it's all just one hydrologic system, and water is really interdependent on each other, whether it's surface water or groundwater. So in 1935, the legislature made groundwater made it fall under the purview of the state engineer for appropriation. So after 1935, you needed to appropriate a water right in order to drill a well. Well, what you'll find in particularly this area is a lot of these wells were drilled prior to 1935. They're old wells. Some of them are very small, and a lot of them were just drilled for the individual domestic units, because at that time, Salt Lake City or whatever culinary service hadn't developed their infrastructure out that far. And so a lot of people just drilled their own wells to satisfy their own domestic needs. And they did it prior to 1935. Of course, there were some that followed that were drilled after 1935, but a lot of these were prior to that. So prior to that comprehensive water law in 1903, water rights kind of fell into one of 5 different categories. You had those rights that were decreed by ecclesiastical leaders. You had those that were filed for record at the county. Those that were decreed by a court, usually those are only between limited parties. Remember, if you want to take something to court, you have a plaintiff and a defendant, and really all the judge is saying, between you and you, this is the law. He's not really saying, well, between you and all these other people that aren't a party to this, he can't do that. His jurisdiction is only between the parties to the case. You have those that were contracts or agreements. Those are quite common in the Salt Lake Valley, especially between Salt Lake City and old irrigation companies. And then you had those rights that never manifested themselves on any record. They just never... These are the ones that were grandfathered in if they were surface rights prior to 1903, if they were groundwater rights prior to 1935. And they just didn't feel a need to file a claim. And technically, they had a water right. They weren't required to. So really, why did they feel like they needed to bother? And so we still have some of those. We often refer to them as pre-statutory rights or diligence claims. And that's one of the things that we try to wrap up in this general adjudication. As a result of the lack of definitive water law, there was a number of issues. First of all, there's no public record. There's certainly no consolidated public record where you could go to one place and find a water right for anywhere in the state of Utah. And since there was no record, there's a lot of over-appropriation. Courts were very good at appropriating more water than the stream could provide. And obviously that led to more controversy. And because those rights weren't defined, there's a lot of controversy, and those had to be settled by the court, or they had to, before the territorial legislature instituted that statute, before the church. So in his biennial report, back around the turn of the century, the state engineer made the following observation. He said, "The definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There could be no safe basis for future work before existing rights are known and made a public record." So the theory was, hey, before we appropriate new water rights, we're going to try to figure out all these old grandfathered rights first, so we get an idea of how much water we have. Well, it's a huge process. And finally, they said, well, we'll just kind of do them in parallel. We'll appropriate new rights and do the best we can to ensure that there's no impairment as we do appropriate new rights. And we'll continue to adjudicate these existing rights. And that's kind of where we are today, where we have the appropriation system where you would go and file for new rights. And you have adjudication, which is looking at existing rights and these old grandfathered rights to kind of bring them on record and provide some clarity. So what is a general stream adjudication or a general water rights adjudication? It's an action in state district court, legal action. It binds water users and the state engineer, and that's the title of code that is governed by Title 73, Chapter 4. And the first general stream adjudications were conducted in the 20s. You remember back in 1919, that's when they finally gave the state engineer the machinery, the proposed determination to really adjudicate that. So we have a lot of the basins that were adjudicated or initiated that time, the Sevier River Basin, the Weber River Basin, Virgin River Basin. Those were all started and even completed. And you see here the Utah Lake Jordan River General Adjudication with a date of 1944. 1944 is being a little kind. It actually started in 1936, and it started because Salt Lake City, there's a huge drought going on. You recall, he's in the grips of the Depression. You remember the Dust Bowl and all that. There's a huge, huge drought going on, and there are people throwing pumps into the Jordan River, taking water out of the Jordan River, out of Utah Lake. And so Salt Lake City filed a suit against like 2,000 people up and down the Jordan River corridor. Well, the court said, well, you can't do that. And really, to get at the heart of this issue, what we need to do is do a general adjudication for the entire drainage. And so when we talk about the Utah Lake Jordan River General Adjudication, which is what this is, we're talking about this entire purple area that goes up into the headwaters of the Provo River up into the Heber Valley, okay, and down into Utah Valley, into the Utah Lake area, okay, out into Cedar Valley. And so you kind of get a sense that this is a big area that we're covering. Now, we're only talking about the West Big Cottonwood Creek subdivision. So to kind of get at this, we take little bites of this at a time and settle those, and then we move on to the next bite. So why do we conduct general adjudications? Well, first of all, we want to bring all claims onto the permanent record. You recall this guy, right? Diligence claims. So prior to 1903, you didn't need a water right for a surface right. Prior to 1935, you didn't need a water right for an underground water right. So that means that sometimes these claims never made it to us, or never made it anywhere. So this is part of this system, is to find those water rights, and that's why we send notice to everybody, right? Because we want to flush those out so we can get them on our records. We also have these things called Federal Reserve water rights, which are kind of a peculiar piece of Americana, I guess, if as a polite way of describing them. So around the turn of the century, there was the Fort Belknap Indian Reservation in Montana. You recall that the Desert Land Act gave states the right to appropriate water rights. Well, the Fort Belknap Indian Reservation tried to appropriate some water off of the Milk River, which runs along their northern boundary. And the state came back and said, sorry, you're out of luck. All of this water has been appropriated. And the Native Americans at the time said, well, that's not fair. The federal government forced us onto this reservation, and now you're saying we can't do what we're supposed to be doing. So there was a lawsuit that followed. It went to the Supreme Court, and the Supreme Court said, by virtue of the fact that Congress had set aside or taken that land out of the public domain, had reserved it, that there was an implied water right that was necessary for those Indians, for those Native Americans. And so why is that pertinent here? Well, the problem is that you can't sue the federal government, right? Unless they let you. They have this thing called federal sovereign immunity. And so they would simply say, hey, let me just back up just a little bit. Subsequent to that Supreme Court case ruling, that concept of federal reserve rights was applied to other federal reservations, such as Forest Service, state or national parks, national monuments. And so in Utah, do we have a lot of national parks? Do we have a lot of Forest Service land? You bet. And the problem is that we couldn't sue the federal government and say, hey, quantify your water rights, because they had that federal sovereign immunity. Well, in 1952, a senator from Nevada, Senator McCarran, finally had enough, because they were dealing with the same thing. And so he drafted a law that's, in a sense, waived the federal government's sovereign immunity with respect to general water rights adjudications, meaning we as a state can sue the federal government, bind them not only in federal court, but we bind them in state district court, which is pretty significant. So the feds have to come to state district court and quantify those rights. And it's really important because you think of all the Forest Service lands we have, all the national parks we have in Utah, those have an implied water right with them. And until the federal government is forced to appear before the judge and participate in this process, they don't quantify them. They just do whatever they want, and they'll take whatever water they think they need, right? But fortunately, there's enough foresight for Senator McCarran to pass this legislation. So now the federal government is required to participate in this process and make their claims and quantify those rights. Another reason why we want to do it is to avoid multiplicity of suits. We don't want people suing each other over ditches and diversions. We just want to kind of get it done in one final suit. Another thing that's common in the West, and this may be kind of the more controversial aspect of this, is that in the arid West, there's only so much water. And, the fairest scheme on earth would be to give everyone the amount of water they want, right, or they need. Well, unfortunately, we don't have the luxury to do that. And so every state that I know of in the West has this use it or lose it clause, in essence saying, if you fail to use your water right, that water can be put to use by someone else. And so you lose your water right if you fail to use it. In the state of Utah, it's if you fail to use your water right for a period of 7 years or more, it's subject to this forfeiture by the court, okay? And so part of this process is to identify those water rights that are no longer being used, that maybe were paved over or abandoned long ago, and just get them off the records. We don't get them. We don't sell them to anyone. In essence, if you have a big stack of paper water rights, you have so much wet water and a big stack of paper water, right? We just move that one piece of paper out of the stack, and the next piece of paper moves on up in the stack of priority. And so in essence, it's a way of ensuring that those people who have become reliant on that water because it hasn't been used by a different water right, it ensures that they're able to do so in the future. Did I see a hand over here? Yes, sir.
Is that use it or lose it clause based on the person, or is it based on the source of the water?
His question is that use it or lose it clause based on the person or the source of the water? It's based on the water right as appropriated. So if you had a water right for irrigation of your lawn for 25 acres, if you had a big lawn, I guess, and you failed to use that water right, you failed to divert water out of that from that water right and irrigate for a period of 7 years or more, that would be subject to forfeiture.
So if somebody were to sell me my property 5 years ago and they had been using it, it might not be subject to forfeiture for another 2 years.
Right. So his continued hypothetical is, if he had purchased this property from a gentleman or someone from 5 years ago and they had used it up to the point in which he sold it, is he protected? And the answer is yes, because it doesn't matter who is using the water under the water right. If it's been used within the last 7 years, you are protected. It has to be not used within that full period, okay? Yes, sir.
How would they determine whether it was used or not?
So the question is, how do you determine whether it's been used or not? So, it's where it's obvious, most of the part. We're not CSI. We're not going to go out and do a lot of investigation, but we have aerial imagery. So if someone says, yeah, I've been irrigating this, I stopped irrigating this 6 years ago, but we have aerial imagery that goes back to the 80s, and so we can see if something hasn't been irrigated. But mostly what it is we come out there, and again, through aerial imagery, this has been a parking lot for 10 years. So, it's the obvious stuff. So what I like to tell people is if you have a water right, if you have a well and maybe it's in some disrepair, now's a good time to kind of get it working again, right? Before we come out and look at it. Because we take no pleasure in making those recommendations to the court. And so I'd encourage people to utilize that water and show that it's being beneficially used so that we can make that recommendation to the judge. Again, the benefit of the doubt goes to the water user. I know there's people that may not feel like that, but we can't come out and see a parking lot for 10 years and then turn a blind eye and make a recommendation to the court, right? We've got to do our job, but certainly we want to give the benefit of the doubt. And if you have questions on how that benefit of the doubt shakes out through a hypothetical, feel free to come up afterwards and I'll kind of give you some sideboards, right? So you know how far is what's kind of a tenuous where you get into some sketchy terrain. Any other questions on that? Okay. Lastly, we want to obtain a final comprehensive decree in this area to get all the water rights, kind of get them that gold stamp of being decreed by a judge. That's kind of the gold standard for water rights. So the adjudication process is kind of a 3-phase process. Right now we're at step number 4. Okay, so we've sent out notice. The petition was made long ago. It's actually issued by a court, like I said, back in 1936 and 44. We sent out notice. We published notice. We sent you the summons. We're having a public meeting now. The next phases, and I'll go into this a lot more in depth, okay, in the next few slides. This is just kind of a thumbnail sketch. And this presentation will also be available on our website in PDF. So you'll be able to download this tomorrow or the next day. So the next step after this, in a couple weeks, you're going to get a notice, and it's going to say, file your claim. And with that notice, it's going to have a water user's claim form. In some cases, it might be one that's already filled out, and we'll get into that. And so that kind of talks about, so that next phase, that blue phase, is really where we send out the notice to file claims, and people have 90 days to file those claims. So that's the next phase. And then those people who fail to file a claim on a water right of record or fail to file a claim at all will be barred from participating further on. So that 90 days is a kind of a critical time. We need to pay attention, and we try to do our best to make it easy. If you don't even know how to fill out that claim form, call us up or come in and we will help you fill it out. Okay, that's our job. Upstairs, we have a whole bank. Yes, sir. That's a good question. Yeah. So this question is, for those of you guys who have shares in an irrigation company, how can we ensure that they're participating so that the company is protected, right? That their assets are protected, their water rights are protected. If you can come and talk to us, and we can see if they filed a claim. We can see where our notices are sent. I encourage you to just come to me, but I actually encourage you to go to the board of the irrigation company and make sure that they're tracking on this process as well. But if you know the name of the company, we can probably figure out where the notices are being sent to, and then we can see if someone has filed a claim and those types of things. A lot of these irrigation companies span multiple subdivisions. When I say subdivisions, not in the traditional sense. I'm talking about little bites of the general adjudication, right? And so in some cases, claims have already been filed in a previous book, and they'll just carry through each book. They don't need to file new claims. They just need to file one claim. And so in some cases, claims may have already been filed on these. And, in some of the, I know in Big Ditch, Salt Lake City is taking care of is filing claims. And I know some board members are actively filing claims. And so Big Ditch, I know, is in this area, and it's also been in other books as well. So I anticipate that. Is that the one you're talking about specifically? I think they are covered, I believe, but we can certainly look closer at that. Big Ditch is a little bit of I'm sure those of you who are familiar with Big Ditch, it's a little bit of an interesting relationship between in Salt Lake City. So we just need probably more, we can have more discussion on what that looks like and some of the complexity associated with that if you want to have a discussion later on. All right, so as I was about to say, upstairs we have a big room full of just water rights, just water right files for the entire state of Utah. Those are water rights that we call water rights of record. You recall on your picture all those little dots. Those are water rights of record, meaning we know where those are. Those are in our files, and so those are what we call water rights of record. Well, if someone fails to file a claim on a water right of record, it goes in this book or this list called the List of Unclaimed Rights. And at the end of that 90 days, we publish that list of unclaimed rights. And in essence, what that says, hey, no one's claimed these. We're going to send it to the court and say, court, by virtue of the fact that people are not claiming these rights, will you please decree them as abandoned? That way we can get them off our books. All right? And so the list of unclaimed, so that initial 90-day period is pretty important for you to file a claim if you do have a water right. Following that, obviously, we've had claims filed, and claims get filed here, and they get filed at the court. Again, more detail to follow on this. All promises. There's a thumbnail sketch here. We will evaluate those claims. My team members will go out, try to make contact with people who've actually filed the claims and arrange time and dates to come and view your water rights in action. We'll make our recommendation, and then that recommendation gets compiled into one big thing called a proposed determination, which then goes to the court, and the court rules on that proposed determination, okay? So let's go into a little bit more depth. So I mentioned earlier that following this meeting, about, I think March 2nd is when we're looking to send out the notice. We are going to send out a notice to submit claims, okay? We're also going to publish that notice in the newspaper just to make sure everyone has access. But again, this is going to all the property owners in that map. And we just go from the county tax records, and that's who we send these to. For those who are simply property owners, yes, sir.
I'm actually buying a property in that
Okay.
division. So will that be mailed to people who own the house right now, or be mailed to?
That's a good question. So he's in the process of buying a property inside this area currently, and he's asking where will that notice go to? We pulled the property records from a month ago, and that's what we'll continue to use. If you are interested in receiving a notice, come talk to us, and we'll just put your name on the list, and just give us the mailing address that you know you're going to get this at, right? And we can certainly do that. Or we can give you a blank claim form, and you can go from there. But if you come talk to us, so the answer to a lot of these questions is come see us, and we'll help you navigate through this process in your individual scenario. So property owners will get, oh, sorry, sir, go ahead.
Yeah, the question I had then, if you have a big, like a big ditch irrigation company, and they have so many claims and they file all this, oftentimes you see the leftover water going down the ditch into the gutter and into the sewer system or the storm drain system. Would this change that to where you're not using or wasting that large amount of water?
So his question is, for instance, big ditch, they turn water out, it goes down past water users, and sometimes terminates into the Jordan River. Now, I met a lady just a couple of weeks ago who said never gets to her end. She's the end of the line on the big ditch. She never sees any water. So but I also know there's a bifurcation. Part of it goes into like the storm drain. Will this change the physical wet water distribution? In theory, it shouldn't. Right? Because big ditch should be operating based off its water rights, and if they file a claim and they've been operating based on how their water rights work, there shouldn't really be a difference in how the big ditch company or any irrigation company distributes its wet water. So ultimately, how that water gets to individual shareholders is really a function of how the board or the big ditch irrigation company in Salt Lake City, I know they have kind of an exchange agreement, how they work that. So long answer, but the short answer is no, it shouldn't. Okay. So if you're a property owner, you're not a water right owner of record. Again, water right owners of record are the water rights of record are the ones we have on our records, right? So if you're just a property owner, you'll receive a notice to submit claim, and you'll get a blank water user's claim form. And it'll look like complete Latin to you, right? You'll have weird terms asking you to do. And so we just really, hey, come in, and if you have a well and you know what you're using it for, we can translate that and get it on this form. We tried to make it simple, but there's some measurements and those types of things that are not going to be intuitive to the lay person, okay? Now yes, sir.
Can we tell from the notice we got whether we're a water user or what?
You can't from the initial notice. The next notice you will, because if you have a blank claim, that's the telltale sign that you're a property owner, okay? Water right owners of records. So these are the people who are on our records who have appropriated these rights or who have updated title with our office. They will, or it may be the dead person who once built your house, appropriated the well, but the water right is just kind of continued in these files under that person's name. Those will be mailed out to the address we have on our records under those people's names, and they will have a claim form that's already filled out with the information we have on our database. And I can show you what that looks like after this meeting. And it essentially has all the fields populated. All it's really required is for the person to make any changes they think they need to make and sign it. And then they can file it with us, or they can file it with the district court. Okay, the Third District Court is the presiding court for this. Judge Lara Scott is the presiding. Again, that information will be on the claim form. So you'll have 90 days from the date of that notice, which will be March 2nd, and I believe 90 days goes all the way till May 31st. Don't quote me on that, but I think that's the 90-day period to file this claim. Okay, so it's important that you file the claim. Come in and work with us. Don't wait till the last minute. Sometimes people will do some wrong calculations and realize that date has moved on. Now, the statute allows the state engineer to provide one automatic 30-day extension if people request it in writing, okay? So if you email me or there's a form on our website saying I want a 30-day extension, you'll have 120 days from the date of that mailing to file that claim. Yes, sir.
What's the question? I have no idea whether I've got, it's on record, I've got a working well. If I've got a working well, I still have to file a claim.
Yeah, so his question is, he's unsure whether...
I've never received, if it wasn't from a neighbor here, I wouldn't even know about this meeting.
Well, so I presume you live within that boundary. So whoever is the property owner for on the taxes received the notice. I apologize if you didn't get notice. We probably need to get your address so we can. But to your question, all right. Your question was, I'm not sure if I'm the water right owner of record, but I have a well that works. Do I still need to fill out a claim form? And the answer is yes. Everyone who wants to continue to perpetuate a water right will need to file a claim.
Second question, if I file a claim, are you guys going to come along and tax me for that?
So his question is, if I file a claim, are we going to come along and tax him for that? No, there's no charges associated with this whatsoever. There's no additional taxes associated with it, or fees, or annual assessments, or anything along those lines. Yes, sir.
Are you going to come along later after that and find out that you got more water rights out than you should and start terminating?
So your question, I'm going to rephrase it, but it doesn't make sense to me. So
What I'm saying is if you have one or you don't have one and you fill the paperwork out to get one, are you going to be denied to keep using it if you've used it for 30 or 40 years?
So let me see if I understand. His question is, if you have one or you don't have one, but you fill out a claim to get one, are we going to come back later? Or so the answer is, if you have a water right and you file a claim and you're using it within the authorized nature of that water right, you have nothing to worry about. Okay. Now, if you don't have a water right and you file a claim, we aren't going to recognize it. We're going to say there's no water right. So you don't get a water right through this process, all right? There will be no water rights created out of whole cloth. There certainly will be water rights that are grandfathered in from 1935 onwards or 1903 onwards, but you will not procure or create a water right through this process. Yes, sir.
Okay, so taking this gentleman's scenario, he has a well, he bought the house, not sure if he has a water right. Let's say it was separated, like you said in that earlier process. And so you're sending the notice out to, let's say, the grandchildren of record or whoever owned that water right. So because he has the working well, and because those people have pretty well not been involved with property in 30, 40 years, does he have a right to file for that claim, or is that claim now given to the state?
So that's a good question.
And then he's done using the water now because these people just let it go because Grandpa told.
Let's not get too far down the hypothetical because I'm going to lose track of the basis of the question. So let me start off in the break it down Barney style, the question you just asked, okay? So in essence, using this gentleman's example, he's not sure if he's the owner of record or whether perchance before he bought the house, someone got sly and said, I'm going to sell this water right to someone else, right? So he's in essence removing he's explicitly conveying the water right away from the property upon which it resides, right? And then you come along, you buy the property. There's still a well there because, heck, he's not going to tear out a perfectly good well. However, the water right now resides with some other entities. Am I on track so far? Okay. So his question is, if you file a claim, is he going to be able to is he going to be able to claim that water right? No, what you're doing is you're perpetuating someone else's water right. The water right doesn't go away, but it's just it's owned by someone else. Now, if you want to enter into negotiations with this person unilaterally and try to acquire it back, but keep in mind, the title has been conveyed, and that's beyond us. It's now it's essentially a property issue, right? If I convey the deed to my car to you, and then I leave it in the shed and move away, and someone hops in and buys my property and starts driving that car, who owns the car? Well, you do, because I conveyed the title to you, even though the other person's driving it. It's the same thing with the water right, okay?
So now, to follow up with that, then, we have the unclaimed property right, because the grandkids are getting papers, and they go, I don't even know what this is, so they don't claim it, it goes into the unclaimed, and here, he has the well, and he's maintaining the well, and he's using it. But now, it's an unclaimed file, it's gone, now it's gone to the state.
That's a good question. So in this scenario, this other entity or this other family just says, hey, I have no idea what this is. I'm not going to file a claim. But this gentleman does file the claim. That would preserve it. That would keep it off the list of unclaimed rights. In essence, we'd be able to say, even though you don't know what your water right number is, we'd say, all right, it's a well located on this property. Let's look at our records. Oh, this is the water right that this claim is supposed to go for. And so in essence, by filing a claim, we would say, all right, this is a claim on this water right number. Even though it's someone else's name, we allow people to be claimants, even though they're not the owners of record, to perpetuate those rights, to preserve them from being considered abandoned.
So he needs to do that because we don't know if his...
Yes, I will repeat it 5 million more times tonight. Everyone needs to file a claim if you're using water, okay? That's, if you get nothing out of this public meeting tonight, if you're using water, file a claim. That's the takeaway. Yes, sir. Okay.
So I assume the same thing would be the process there. If I just want to file on behalf of the HOA, I would just go in and say, there's this water right here, which I don't even know if we have one necessarily.
Yeah, so his question is, he's the president of HOA, and if, for instance, there happens to be a well associated with HOA, or maybe just a well within the HOA, would he be able to file on it? He could. You could, and we'd come and evaluate it, and if it was being used, we'd make our recommendation. Doesn't mean the HOA would now be the owner of the well. That's a different process to update title to that water right. But certainly we want people to preserve these rights. If they're being used, we want people to perpetuate those. We want people to use the water. Okay. So once these claims are filed, then we do an evaluation of these claims. And so what will happen is you'll file the claim, they'll kind of go in a pile, and then my team leaders will go through that pile, they'll look at the claim, they'll see the contact information, they'll try to arrange a time and date that they can come by and look at the claim, or look at the water right. Observe the well, observe the irrigation, observe that it's connected to your house, those types of things. And then they use that investigation to make a recommendation, okay? And that happens on all claims we receive. List of unclaimed rights. We've touched on it pretty heavily so far. For those water rights of record, where people don't file a claim, even if it's, someone doesn't own it, if they file a claim on it, it'll go off that list, so you don't need to worry about it. But for those rights that make it onto that list, we will publish that. We'll send it to the same people that received the notice for this tonight, okay? So you'll receive notice. It'll just be like a one-letter sheet of paper, and it'll say where to access this so you can see what rights are on that list, and it'll have a time and date for a meeting, for a public meeting similar to this, where we explain and answer any questions. Usually we get about 3 people show up to this public meeting, so it's really well attended. People, if they don't agree with the list of unclaimed rights, let's say for sake of argument, we forget to file a claim, or there's some instance where you just can't do it within the 90 days or the 120 days, and a water right of record gets listed on the list of unclaimed rights. Well, you have 90 days to file an objection to that list. So you have an opportunity to disagree with what we put on the list. At the time you file an objection, you have to file it with the district court, and then you file a claim with it. All right, so you file your water users claim with your objection, and you provide a copy of that claim to the state engineer. Did you have a question, sir?
In light of this whole thing, using that guy's example, he didn't know a thing about this meeting, he didn't get any mailing, so you're just compounding the continuation of the unknown. So how would people that aren't getting the notices be able to act on this? Because that's a big issue. I can see if he wasn't here, his water right could have been on that list of unclaimed and gone away.
So the question is, what really, if I were to kind of summarize your question, what precautions are we taking to ensure that notification is made so we avoid people abandoning their water rights without knowing it? All right. What are we doing from the Division of Water Rights? Well, obviously there's nothing that's 100% foolproof, but we get pretty close to it. Okay. So, for instance, this subdivision, we sent out over 6,000 notices. All right. We also publish it in the newspaper, and I recognize people don't read the newspaper anymore. I get it. But we're trying to do everything we can, right? And so at the end of the day, we expect people that really the burden is on the water user themselves. If they have a water right, they should be familiar with it and should be able to know how to handle it and know that it needs to be something to be taken care of. But you're right, nothing's 100% foolproof, and it never will be. But we do go through great efforts and great expense. So 6,000 notices times 3 notices, you start to do the math, the dollar figures add up pretty quickly, just for one subdivision. I'm doing 20 of these right now, okay? And so we really, so what I'm trying to communicate is we go through great effort to provide that notice. And we're not statutorily obligated to send notices to property owners, but we do because we want them to be part of this. And so I'd encourage you, if you feel like you didn't get the notice or if your neighbors didn't get the notice, let us know and we'll put you on our mailing list. But again, there's nothing that's 100% foolproof. Yes, sir.
Yeah, so if you buy the property and you get the water to use the property, but you're not using the water, but you want to use it later, you lose that right if you don't keep it active and keep using it. I don't get why it would get taken away from you if you have that water need that came with your property. I mean, what if I don't want to use it now and, we get in a worse drought down the road and I want to use it and then I lose it because I wasn't using it already?
So his question is, if I were to summarize it, it's unfair that that people who don't use their water rights, who may want to use them in the future, it's unfair that they get recommended to be disallowed or potentially forfeited by the court in essence, right? What gives us the reason? Why is that the reason? And so let me flip that scenario on its head. Okay, let's say you're not using this water right. You're not using the water associated with your water right. In the meantime, whole subdivisions have been built dependent on that water that isn't being used by you. And then suddenly, 20 years from now, that water suddenly starts being used, and now all these subdivisions and houses and communities that become reliant on that suddenly find themselves impaired. And so that's the real crux of why it's a use it or lose it. I totally get that it seems unfair. It's a property taking, right? But really what it is, it's to ensure the most equitable use of a limited resource. Again, the most fair scheme would be to give all the water to all who need it all the time. But we don't have that. We have a limited amount of water, so this is the best mechanism that the state legislature, not us, has determined to administer those rights. Yes, sir.
Now, I have a well. The well is impaired, but it was impaired by the city. The city sunk some big 24-inch wells around the neighborhood. The whole neighborhood's water settled. We had a hard time getting to it. So the city water came in and put in, that's all we had was wells. So the city came in, ran the line, and we had to hook up to that.
Mm-hmm.
What and when does that impairment create a problem for me?
So his question really has to do with impairment, right? And he gave this situation or scenario where he had a well, some big municipal wells were drilled, and water was taken out, and it impaired his ability to get water from his well. And so really what we're talking about is impairment, and impairment's not really a process or something considered in the general adjudication, really. Really, the opportunity to protest that well would have been when the city filed its applications to drill those wells. Also, at any time you feel like you're impaired, you can certainly go and take the city to court saying you're impairing my well. So there's avenues for relief, but it's not through this process. It's through own legal proceedings or through the application process. In the state of Utah, kind of an interesting side note is that the case law is that people are obligated to chase the water. So if your if you have a well and the water table starts to diminish, well, it's your responsibility to keep getting your well deeper to chase that water. Now, whether that's fair or not is certainly up for debate. But that's what the Supreme Court has ruled. But again, your opportunity for relief would be through the courts, through a unilateral, probably lawsuit. But I would certainly not take my word for it. And I'm sure Ben's over there saying, just don't give legal advice. Don't give legal advice. So I'm going to tell you, seek competent legal counsel before doing anything I just told you to do. All right? But the general adjudication won't resolve that. Fighting the government, yeah. The government's got your water. No, and I'm not trying to be cavalier, but I wish there was some way we could resolve that. Again, I wish there was a way we could make things fair. And we try to where we can. In this instance, we have zero power over that particular scenario.
Do you grant them the rights to go deeper, though, like the city or Jordan Valley or whatever?
Do we grant them the rights to go deeper? When they apply for their application to appropriate, they are given a depth that they are to drill their well to. And that is then advertised. People in the surrounding area have an opportunity to protest that application. And so, in essence, yes, the state engineer authorizes how far their well goes and into what aquifer, but that doesn't mean that the public doesn't have any say on it. Again, they are encouraged to come forward and show impairment and say, no, this well will impair my well. But understand, I know we're not all reading the newspapers looking for public announcements to figure out how to. Yeah, and I'm not going to spend a whole lot more time on this because it's really have a zero influence, and I want to make sure we get through this presentation. So maybe is it all right if we move along and we can talk wells all night? If you want to come up afterwards, I'll listen to you all night long. I'll be your whipping post. No big deal. I'm used to it, right? But let's talk about the objection period for the list of unclaimed rights. So you have that 90-day opportunity to object, where you can file an objection with the court, and you can file your claim at the same time. You're also obligated to file your claim with the state engineer. So what that does is, and really we don't really oppose those. We encourage people to file those claims, and if they've been listed on a list of unclaimed rights, we want to make sure that they get off of it. So if there's a legitimate claim, we certainly welcome those, and we don't litigate those. We pretty much just accept them because we want people to file their claims. I guess we could, if there was someone who simply took the list of unclaimed rights and filed a claim and objection for all of them, we'd probably litigate that because obviously they're just doing it for speculative purposes. The judicial decree, again, for the list of unclaimed rights, in essence, it decrees all of those water rights on that list as abandoned, and so in essence, they just go away. They remain on paper here, but they're not useful anymore. And it also shuts the period. It turns off the opportunity for people to file those diligence claims, the old timers, the ones that have been grandfathered in. You can no longer file a claim once that decree has been issued. So this is a way of kind of turning that off so that all this uncertainty about, well, we don't know what old rights are out there, comes to a conclusion with that. So the proposed determination, you recall, you file claims, we've come out, we've evaluated it. Well, we get all these, we do our evaluation, and then we send a copy of our evaluation to the individual the claimant. So, hey, just so you know, this is what we saw, this is what it looks like, this is what we mapped. And then we compile all those recommendations into what's called a proposed determination. And we mail, again, the same notice, but this notice only goes to people who have filed a claim, or water right owners of record in the proposed determination. So if you're a property owner and you don't participate, you won't get notice of this except for in the newspaper, all right? We'll have a public meeting. Again, people will come and we'll explain what the proposed determination, the sections entail, and how to read it. Again, people have 90 days. If they don't like what the state engineer has recommended to the court, they have 90 days to file an objection. Again, they must do that at the district court. before we can petition the court for a decree, we have to resolve objections. Usually what that happens is, if there's an obvious mistake that we made, we are happy to negotiate a settlement and recommend to the court that it be amended to recognize that, right? But if it's something more controversial, or for instance, what if you don't like your neighbor's right? You don't like the fact that he got 25 acres and he should only have 10 acres. You can object to his rights. It's not just your rights. And so this is part of the process we have to do to resolve those and ultimately have the court dismiss them either through litigation or negotiated settlement. And then we petition the court for a judicial decree which in essence decrees all the water rights of the proposed termination. All right, I'm almost done. I'm going to do this quick and then we can have as many questions as you want. You have that map. I've already explained what it means. You see all those purple clusters there. We have about 982. I guess I was wrong. I said 600 before. 982 water rights of record in this subdivision, which is quite high. Most of the rights are underground rights, meaning they're wells, okay? Number of people or entities we've notified, around 6,000. Issues and anticipated timeline. Some of the issues are that people have out-of-date title. For instance, this gentleman who has a well doesn't know if he's the owner of record. He maybe acquired the property from an earlier successor or predecessor in interest. If you want the water right in your name, now this is kind of counterintuitive, okay? The county recorder is the office of record, meaning that is where property rights are recorded. So because you're not the property owner or the water right owner of record that we have, doesn't mean you're not the owner of the water right, but we just don't know it because all these deeds have transferred, but the county recorder doesn't communicate with the state engineer's office. And so if you want to update ownership to the water right that you're filing a claim on, there's a process called a report of conveyance, which walks you back. And in essence, what it does is it finds the original appropriator, it finds the property deed with the same name, and then you walk that chain of title forward to present day. And there's a report that's done. It has to be done by a licensed title professional, professional engineer, professional surveyor, or an attorney. We can show you where to do that. That's outside of the general adjudication. You don't have to do that to participate, though. The next thing is the location of these no proof required water rights, or otherwise we call them NPR sometimes. There's a lot of them in this area. What happened was, back in the 40s, there was quite, there wasn't a lot of engineers around because they were all off fighting Nazis somewhere. And so what the state said, well, for a small amount of water, we won't require proof. In a traditional application of appropriate, you would apply for a water right. The state engineer would say, all right, you have an approved application, and then you would work diligently to build the well, use the water, and then you'd file a proof saying, hey, I've done this. Here's my proof. Here's a map of where I'm irrigating. This is what the structures look like. Well, in essence, they waived that requirement for a proof for these small amounts of water because there weren't enough engineers or surveyors to help them do that. And so what happened as a result of that is that these water rights, or the locations of these wells, were kind of best guess estimated. There was never a proof map saying this is where the well is. And so those dots that we have on the map may not be exactly where they should be for a variety of reasons. So Tamara has some maps that she's going to spread out, some big aerial imagery maps with these points on them. You'll probably see, well, this well says it's in the middle of the road, or it's in the middle of my shed. That's not where the well is. That's probably because of a couple of reasons, but a lot of it has to do with these no proofs required, and there wasn't a very good location submitted for those points of diversion. So anticipated timeline, I said March 2nd, we're going to send out the notice to file claims. You'll have 90 days. June 2018 is actually, I guess, May 31st is the last day to file a claim. So the 90-day claim filing period concludes May 31st, June 1st. Then you have the 90-day then the state engineer will publish a list of unclaimed rights in August of 2018, holds a public meeting. Then you have that 90-day objection period in November of 2018. The 90-day objection period concludes. And then we go down, and you wonder why there's such a big gap between November 2018 and February 2020 is because now we're evaluating all these water rights. And because of the complicated interconnectedness of all the water rights in the Salt Lake Valley, what we've decided to do is take some additional time to make sure we get these things right and hold off on publishing these proposed determinations until a little bit later, just so we can get them all figured out and consistent, especially with all of Salt Lake City's exchanges that they have, just to make sure that we got it right so that we're not publishing something that doesn't make sense that we regret later. So we have a little bit of extra time built into that time frame. And then in May of 2020, the 90-day objection period will conclude, and we'll petition the court for an interlocutory decree. Will I lose my water right? We've kind of talked this over. Those who are using their waters, the water right in the conformance with the records of the state engineer have nothing to worry about. We just say keep on doing that. Those individuals without a water right of record are required to submit a claim, or they will risk being barred from doing so in the future. Again, the greatest lesson learned tonight, just file a claim. Now make sure you don't just file a claim that has nothing on it, because we'll just kick it back to you, all right? Or if it doesn't satisfy the needs of what needs to go on a water use claim. So any question, come in, we'll help you. Again, if water use authorized under the right has fallen out of use for a period of 7 years or more, the entire water right, or even a portion of it, let's say you had a water right for 10 acres and you've only been irrigating 5 acres for the last 7 years, we would recommend a portion of that be disallowed or forfeited, so your water right would go from 10 acres down to 5 acres, or to 0 acres if you had failed to use it for the last 7 years at all. Here's the contact information. That's my name at the top. Gary Brimley is kind of my deputy. And then Tamara Prue, she's going to be the person you're going to get to know, okay? Her team and herself, she'll be the one that will be scheduling appointments, or her team members, and coming out and actually visiting with you, observing your beneficial use, and she'll kind of be the boots on the ground team leader. So with that, let me just check my email really quick and see what type of questions I got, if any at all. I don't see any. Oh, I got one question. Yes, this is a Tina. She asked, can you send me a copy of the map with all the little purple dots? Yes, Tina, I will email you something tomorrow. Sir?
I have a question. So once we file for that, will we actually have a piece of paper that's issued to us that shows like a deed or something?
So this question is, if you actually file a claim, will we be issued a deed or a certificate of some variety that shows where the owner claimed it? The answer is no, because we aren't updating title. You need to go through the report of conveyance. And again, we're not, there are no deeds involved from our perspective. Now, we will send back what we call a state engineer's recommendation with your name on as the claimant, showing that you claimed this under this water right, but that's about the extent that you will see anything with your own name on it, unless you are the owner of record. Okay, so there will be some confirmation, but it's nothing official. It's just simply to say, we recognize you've claimed this. This is what we're saying the water right looks like. It's still going to be in the name of the owner of record when we publish it in the proposed determination. Yes, sir, and then I'll go to you. No, so the county recorder is where you would go find deeds and conveyances, right? So to your property. The water rights of record are upstairs. So water rights upstairs, property records, county recorder. Okay. These don't always communicate. Right. And so really what you need to do to update title to these water rights is find all these deeds, this chain of title that shows you have the original appropriator. Let's just say Joe Smith was the original appropriator, and he's the original owner of this property. So he had a deed to the property. He's the owner of water right record. Well, he didn't convey the water right by deed. He just was silent, but he conveyed property to Brigham Young, who then conveyed it to Wilford Woodruff, and then to you, right? And what you need to do is go get the county recorder and say, all right, I have the chain of title from me, from Joe Smith to Brigham Young to Wilford Woodruff to me. Update the water right accordingly by a pertinence, assuming that there was nothing explicitly withheld, and that's what's entailed in the report of conveyance form or process. No, what you should do is probably find a water rights professional, title professional, and they know how to do this, and they just do it all. Now, if you go and do your own work and find the chain of title, and you provide that, that might save you some bucks from their point of view. But the state requires a title professional to do that work in this type of instance.
Okay.
Yes, ma'am?
So if I claim my water right and I'm selling the property that's currently on the market, can I keep the water right and sell the property?
So her question is, if I'm currently selling my property and I claim a water right, or if there's a water right on the property, can I keep my water right and still sell the property? Yeah. I mean, and how that works is when you convey your property, again, seek competent legal counsel, full disclaimer, you explicitly withhold any water rights. You just blank statement, explicitly withholding those water rights, and that in essence severs those water rights from the land. Now, and then if you're going to try to market those, you could certainly give it your best shot. Because someone's probably not going to, a smart person is not going to buy a water right that's of no value, right? And so if a water right is not been used for 7 years, or if we've recommended it be forfeited, someone's probably not going to buy it. You might find some sucker on the street to buy it, but I guess that's up between you and them and the man upstairs. Hold on, this gentleman back here.
I was just going to say, wouldn't you have to be able to use that water right? You have to use it, right?
Yeah, so his question, wouldn't you have to use that water right? You can sell whatever, right? I can sell you beachfront property in Arizona if I wanted to, if you're willing to buy it. But yeah, for it to be an effective water right or an actual water right, you've got to perpetually use it. And most people who are in the market of buying water rights understand that principle. So you probably have a hard time, not everyone, unfortunately, but a lot of people who are in the market for buying water rights understand they're going to buy a water right because then they're going to have to file a change application and move it into their own well or move it somewhere else. So for the most part, people who are in that market understand that. Did I see another? Yes, sir.
So, I bought my property 25 years ago, and the original owner gave me all the paperwork and fees and that on the well. So do I need to go to the county and change that into my name, even though I got all the paperwork?
So his question is, I bought my property a long time ago. I was conveyed all the deeds to the well and those types of things. Now, do I need to go to the county and get that squared away? You need to make a distinction, and it's counterintuitive, between the well and the water right. The well is a physical piece of property on your property. It's like a barn, right? When you buy the property, you own the barn. Okay? The water right's like the stock in the barn, right? You may or may not own that water. So it's not the same. That's a terrible analogy. Forget that analogy 100%. So just because you own the well doesn't necessarily mean you own the water right. Probably does. Probably 90% chance it does. But they could have always explicitly withheld that or whatever. But if they have that boilerplate language conveying all the water rights and all that, it's likely that you are the water right owner. Again, that's where that water right report of conveyance process comes into hand. We have a list of water right or title professionals who you can go and they will be able to give you an idea of a cost to get that water right in your name. In your name. So why would you want the water right in your name up here, right? You're using the well. Why do you care whether it's on our name or not? Couple reasons. If you ever wanted to renovate the well, make it deeper, make it bigger, whatever, you would have to obtain a well drilling permit, and those are only issued to the people who are the owner of record on the water right. Okay, so that's one reason. Another reason, if you ever wanted to sell the water right, that's another reason. Or if you wanted to change the water right. We didn't want to do anything with the water right other than just continue to beneficially use it. You would want your name as the owner of record.
So how do I find that information online?
How do you find what information?
Switch that, you said.
I can show you. Yeah, it's on our website. And we can give you some contact information, the people who handle that. The first point of contact is seeking a title professional and kind of touching base with them and saying, I want to update this water right. I guess the first step is to determine you actually have a water right that you want to update title to, right? And so you'd go and find the well, go find the respective water right number associated with it, and say, I want to update title to this water right, and then take that to a water right title professional and say, I need this in my name at the state engineer's office. And they'll go to the county recorders, they'll do all the research, prepare the maps, and then file it with the state engineer, obviously for a fee. Okay. Yes, sir.
So it kind of sounds like what I'm hearing is that there's a lot of times that these guys had these water rights, 40s or whatever, they drilled these wells, and then they sold these properties, and let's say over the next 30, 50 years, this property was sold on average every 7 years. And Bob, the well driller guy that put it originally, he may have separated it or he may not. So what you're saying is the title conveyance can say it's still part of the property, it just never matriculated with every time that the house was sold. And that's why you have it up here sitting in your file again, because those people are long forgotten this stuff. This was there. Is that kind of
Yes, that's a fair summary, right? That you have the original guy who drilled the well, and he is since, he drilled it back in 1925 or whatever, and maybe he filed a claim later and made it of record, and it's on our records under his name upstairs, and then he sold his property, and he simply said, with all water rights, whatever, and so it conveyed silently down the chain up until the present day owner. However, although all these deeds and everything have been recorded at the county, nothing has been communicated to the state engineer's office that, hey, we've sold this, this is the new owner of the water right, this is the new owner of the water right. So we need to recreate that chain, and that's what the title professional's job is to do, is to recreate the chain down to the property owner. So we call it unity of title between the property owner and the water right owner. And then once you get that, then you can bring it forward to present time. They'll reconstruct the chain of title and file.
So if this was sitting up in your drawer and nobody's even thought about it for 50 years, that's that process that's going to come down and need them together. Right?
Yes, correct.
And if, what if they say, well, he separated them, but everybody at title assumed that they forbade? Is that when they file a claim, are you going to be able to come back and say, he separated this from the property, and everybody, because you said it's this kind of boilerplate language, they believe that they've had this water right.
So when we get the claims, we don't look at title. We just look at what the beneficial use is, and we let the title section upstairs deal with this report of conveyance. And the title professional who's responsible for recreating that chain will be able to determine whether that water right was conveyed out of the chain of title or not. At the end of the day, it's on their professional record, and so they're submitting something as a professional saying, this is the current owner, here is the information that demonstrates that. And if they fail to find that it was explicitly withheld or moved away, that's on them. But at the end of the day, someone could always say, no, I got it, and they could file a competing report of conveyance and update title. So that's the challenge, and that's really why we require title professionals to take care of it, because we assume they know what to look for to avoid that.
So when he says he's had his for 25 years, assumed it has moved along, he files the claim, and then you guys come back and say, no, it was separated a long time ago. It's Jim Bob Fleming from New Orleans owns this.
Yeah, we aren't going to come back and look at anything through the adjudication process. Now, if the title professional discovers that and discovers that title is frustrated or clouded at some point in that chain of title, he may make that assessment. But from our point of view, the water right is still valid, it's still being used, it's just in under this owner's name. And if he wants to obtain title to it, then he needs to go find out whoever now owns title to it and obtain it.
But he can claim the right and then keep using it.
Yes, he can still file a claim as a claimant, regardless of who the owner of record is.
Okay, so that's why you're saying.
Hold on 1 second. What's that, Tamara?
If you were one of the people who were saying you were gonna get your paperwork mailed to you and wanted to be added to the list, can you come find me and I'll
Yeah, so if you didn't receive notice of this, you want your address or mailing address added, see Tamara back there, please. She'll add you so we can make sure we notify you of future meetings. So I'm going to take an opportunity now to go through our database and show you how to navigate. So there's some really great online tools that we have that will help you identify what water right may be associated with your property, okay? So I'm going to take some time here, and what's that? You're wrapping it up, right? Yeah, we're done, or we can keep on rolling? All right, we'll roll with this. All right, let's get the internet up here. So our water right, our address is waterrights.utah.gov. It should be on the notice you receive. So this is our home screen. Oh, are you going to fix the aspect ratio? Thank you. So this is the home screen. If you want to see if you want to look and find your house, you would go to Data, GIS/Maps, select that link, and then up in the upper left-hand corner, there's a link that says Water Rights. Select that, and then you just go to the first hyperlink, Adjudication Areas, and select that. And you'll see it brings up the entire state of Utah. Now you see all these purple lines superimposed over the aerial imagery. These represent the different adjudication subdivisions that the state of Utah is conducting. We'll kind of zoom in to the Salt Lake Valley. And you can see the bites get smaller and smaller the more densely populated the area is. And let's go down. Let's find this particular subdivision that we're currently involved in, which is the West Big Cottonwood Creek 5717. You can see the number right there, okay? Center of the screen, which looks just like the map on your notice. So I'm going to zoom in just a little bit. Now I go over to this menu on the right-hand side, and you'll see that there's some buttons you can select. And these are all different things you can play around with, but I'm just going to select points of diversion, okay? I select that and then give it some time. Those are all the wells in this particular area, okay? Now, someone give me, so you can use these other features if you want to find your address, if you're not very good at kind of scrolling around on aerial imagery. So, what's your address? 40, sorry, so it's, okay. And I know you're not really in Salt Lake City, but Salt Lake City works for this purpose. And I can just abbreviate Salt Lake City. And it'll take me to the address, okay? And so that should be your house, right? So in this view, it doesn't show a well in your yard. It does show one in this yard, but again, you got to take that with a little bit of a grain of salt, because it's really that the location of that well could be off. It could be in your yard for all we know. And so if you have a well in your yard, it could be that water right number, right? That's probably the best candidate. So that's how you would determine. And then what you can do is you can select on the icon, the well icon, and you'll see it has some basic information. Has the status, which is an abbreviation for application NPR, or otherwise no proof required. Remember, those are, and then it has, those are the funky locations. Has the owner of record, John Antonchik. But what I want to show you is this. If you go to the water right number and select the hyperlink, it'll bring up our database. And it'll show you what the water right looks like on our database. And this kind of probably provides you with more information than you really need to know. But what I want to bring your attention to, or direct your attention to, is the water use down here. This shows that this water right was approved for one domestic. It says 1 EDU right here. Okay, that in essence means one equivalent domestic unit, or one house. So that's what that water right was originally appropriated for back in 1952. There's the priority date right there. Okay. So that's the main thrust, and you can certainly play around on this. There's some other search features. There's different type of maps with different imagery, and even quad maps or USGS maps if you're ever in a bind and want to have easy access to a quad map or a USGS map throughout the state of Utah. Any questions on this? Okay. That pretty much, let me just see if there's any more questions from my email. I see none. That concludes this presentation. Thank you for your time. Happy to answer any questions offline if you have more specific questions. Sure.